According to this new 1835 Patent Act, we're now supposed to, deal with patents, specifically.
What does deal with patents specifically actually mean, Wilberforce?
I haven't the foggiest idea. The Act says we should handle patents, but doesn't explain how, when, where, or why.
Excuse me, I've invented a machine that invents other machines. Could I patent it?
The machine, the machines it invents, the reasoning method, or the abstract concept of machine-based invention?
Well, all of them?
But who's the actual inventor, you or the machine?
I invented the machine, but then it improved its own design and built a better version of itself.
I think I need to lie down.
Welcome to 1835, when Parliament decided England needed better patent laws but forgot to explain what that actually meant. 17 years of patent confusion later, Parliament tried again with the Patent Law Amendment Act, 1852.
Gentlemen, we now have actual procedures, commissioners of patents, official seals, registers, provisional specifications.
What exactly distinguishes a complete specification from a provisional one?
Excellent question. A complete specification is thoroughly complete, whereas a provisional specification is merely provisional in its completeness.
I see. And what makes it complete?
Well, it's not provisional, obviously.
The 1852 Act introduced revolutionary concepts that nobody quite understood yet.
I'd like to file a provisional specification for my mechanical shearing machine.
Mechanical shearing machine. How delightfully agricultural. You know, I once saw a sheep. Lovely creature. By the way, that is 6 months of provisional protection while we provisionally process your provisional application through our provisional system.
What happens after 6 months?
Complete specification, which will completely process through our complete system. Speaking of complete, I completely forgot to mention, do you happen to know anything about sheep or goats?
What's the difference?
Well, a sheep is more of a woolly creature, whereas a goat...
Between a provisional and complete.
Oh, well, yes. The complete one is processed completely, whereas the provisional one is only processed provisionally. It's the difference about the same as the difference between a sheep and a more complete sheep.
The Act also allowed third parties to oppose patents, though nobody specified what grounds they could use.
I object to that patent.
On what grounds?
The inventor has a stupid hat.
I see. And is the hat mentioned in the specification?
Well, no, but it's quite stupid.
Hat-related objections. Let me check the manual. No guidance on millinery. I suppose we'll have to wing it.
The 1852 system worked, sort of, but created as much confusion as it solved. By the 1860s, the patent system had become a bureaucratic maze that challenged human sanity.
Now remember, Pemberton provisional protection lasts 6 months, unless it's for a complete specification, which also gets 6 months, but it's a different 6 months. A provisional specification provisionally specifies what might be specified, while a complete specification completely specifies what was only provisionally specified and unspecified.
But what are we actually specifying?
The specification of specifications, of course, unless we're specifying the provisional completion of a complete specification, in which case we do not specify anything specifically.
I think I need to lie down.
Splendid! I think that means that the system is working.
Revoking patents required a medieval legal procedure called writ of scire facias that nobody understood.
Your Honours, I don the sacred wig of revocation and invoke the writ of scire facias.
Why are you wearing a Viking helmet?
It's traditional legal headwear.
Since when?
Since tradition began.
I brought a jousting lance. Is that required?
I have no idea what any of this is for.
Neither do we.
Parliament finally got serious with the Patents, Designs and Trademarks Act, 1883, creating the actual UK Patent Office.
Behold, professional patent examination, distinct statements of invention claimed, 9-month provisional protection periods.
This application will be examined for novelty, utility, and moral uprightness. Moral uprightness? Your automatic hat-tipping device must not encourage improper social interactions.
It's just a hat that tips itself.
Exactly. Automated courtesy could lead to the complete breakdown of genuine politeness.
The 1883 Act replaced medieval writ procedures with modern court proceedings.
Patent revocation will now proceed under clear statutory grounds rather than ancient writs nobody understands.
Thank goodness, no more scire facias.
Indeed. Though we still have no idea what we're doing with most of this.
The 1883 Act established the framework that would travel to British colonies around the world. Patents now require distinct claims, professional examination, and systematic opposition procedures. International cooperation meant inventors could protect innovations across multiple countries with coordinated timing. This sophisticated system was ready for export to British colonies, where it would face entirely new challenges.
Our modern patent system will work perfectly in the colonies. After all, what could be different about patenting sheep shearing devices in Australia versus England?
Sir, we're receiving some rather unusual patent applications from the colonies.
How unusual could they be?
The Patents, Designs, and Trademarks Act, 1883, transformed English patent law from medieval chaos to modern administrative efficiency. Provisional and complete specifications, professional examination, systematic opposition, and international cooperation. All the tools colonial patent systems would need. But would Victorian patent bureaucracy survive the Australian bush, where inventors dealt with challenges no English parliamentary committee had ever imagined? Next time, English patent law meets the Australian colonies, where distance, deadly wildlife, and sheep-related innovations will test every procedure in the 1883 manual. Like and subscribe for more Imagine IP. Thanks for listening, and as always, keep imagining.